I'm showing 5:30, so we'll go ahead and call the meeting to order. I want to thank everybody for being here. Our February meeting of the Volusia County Charter Review Commission. Madam Secretary, can we start off with a roll call, please?
Yes, sir. Mr. Watts.
Present.
Ms. Northey. Ms. Bright.
Here.
Mr. Clayton.
Here.
Mr. Johnson. Here. Ms. Kwiatek. Here. Mr. Lewis.
Here.
Ms. Munizzi.
Here.
Mr. Parker. Here. Mr. Sakhnovsky.
Here.
Ms. Schreiber.
Here.
Ms. Wheeler. Here. Ms. Walford.
Here.
Mr. Tolland.
Here.
Great timing, Mr. Tolland. Well done. All right. So we've got a full board, it looks like, today.
No,
Nate's-
sir, we've got one.
We've got one that's may show up here shortly. All right. Well, I'm not going to give a whole lot in the way of welcoming remarks today because we have a number of things to work through. So we'll move on to action items and ask to approve the meeting minutes from our January 12th, 2026 meeting. And I understand there's one correction, Madam Secretary. Oh, nope, I think that's on the, is there a correction on these minutes or it's on the committee?
No, sir, the question's on the other minutes.
All right, we'll get to those in a minute then. All right, is there a motion on the minutes? So moved. Got a motion from Ms. Northey, second by Mr. Parker. All right, any discussion on the minutes? If not, all in favor signify by saying aye.
Aye.
Any opposed? All right, the minutes pass. Moving on to general business. Madam Secretary, do we have any public participation this afternoon? Give us just a second, we'll get you called up. Okay. Catherine Pente.
Hi, good evening, and thank you for the opportunity to speak. I'm here to urge this commission to recommend a Volusia County Charter amendment that mirrors Alachua County's protections for public conservation land, specifically an amendment that requires a countywide voter approval before protected lands can be sold or converted for incompatible uses. This is not a radical idea, it's a proven one. Alachua County adopted this safeguard in 2008. It protects irreplaceable public lands while preserving accountability and flexibility. At its core, this amendment rests on a simple principle. Land that was acquired for conservation, recreation, or cultural purposes should not be disposed of or degraded without the consent of the people who paid for it, preserved it, and rely on it. The Alachua County model does three very reasonable things. First, it creates a public registry of protected places, adopted in the open at a public hearing with clear explanations of why each property matters. Transparency is good for the government. Second, it says that once land is placed on that registry, it can't be sold or converted in a way that destroys its conservation value unless the voters agree. That doesn't ban change, it simply puts irreversible decisions in the hands of the people. Third, it allows for necessary exceptions like state or federal eminent domain, so this doesn't interfere with higher levels of government. This kind of protection matters, especially in Volusia County. Our conservation lands protect springs and rivers, including the St. Johns River system. They absorb floodwaters during heavy storms, help protect homes and neighborhood along the coast, and they serve as natural buffers against storm surge, erosion, and sea level rise. These lands save taxpayer money while protecting the quality of life. Once land like this is sold or converted, it's gone forever. We don't get the floodplain back, we don't get water quality back, and we don't get resilience back. A charter amendment is the right place for this safeguard because it rises above politics and election cycles. God bless you. If this doesn't question anyone's motive, it simply ensures that decisions with permanent consequences require public consent. Alachua County has shown this works. Volusia County has the legal authority to do the same. I respectfully ask this commission to recommend a charter amendment that mirrors Alachua County's protections and ensures that the people of Volusia County have the final say over a sale or conversion of our most important public lands. Thank you for listening and for your service on this commission.
Thank you very much. Appreciate your comments. Any other members of the public? Any other members of the public that would like to say anything? All right. Then we will move on. We have a presentation this evening. Nick Dunham with Volusia Forever. Thanks for coming out. We appreciate your time tonight.
Thank you, Nick Dunham, the Resource Stewardship Director for Volusia County.
What I'd like to do real quick is just go over the process and flow chart for conservation lands in Volusia County for the Volusia Forever program. So it starts with the cycle. So we have an open cycle year-round for Volusia Forever. So a landowner can submit an application at any time. An application comes in with a willing seller letter. So that's important. This is a willing seller program. So staff will take this application, willing seller letter, and score it against 21 specific criteria that are related to the goals in the ballot language for Volusia Forever. Once staff has evaluated the application against those 21 criteria, they are then presented to the Volusia Forever Advisory Committee, who will then determine if that a property is eligible or ineligible as a conservation land under Volusia Forever. If it is ineligible, the property stops there, it does not move forward. If the property is determined eligible, it moves forward to the next step of the process, which is sorting. Staff then prepares a comprehensive report on the property and presents that to the Volusia Forever Advisory Committee, who then determines whether that property should be sorted into the A list or the B list. The A list being the highest priority acquisitions by council. After that, the Volusia Forever Advisory Committee, after the Volusia Forever Advisory Committee has sorted the properties, it is then taken to county council for approval, and the county council will either add or deny those properties to the A list. After a property has been added to the A list, staff can then start negotiating properties with the landowner. At that point, title work is ordered, appraisals are ordered, and negotiations begin. Once a property has been agreed to in a negotiation, it is then brought back to county council for approval. Once a property is approved by county council, then it goes through the due diligence and closing process. So surveys, environmental assessments, and the rest of the due diligence process. Once the property is closed, then we move into post-acquisition part of the process. That is the part where a lead land manager is assigned and a land management plan is created for the property, and it is open to the public after that. At the very end of this process is the property is taken to the PRDRC committee and placed under a conservation status and zoning for the future. So with that, is there any questions?
All right, Mr. Dunham, thank you for the presentation. Let me open up and see if there's any questions from members of the commission. I have one for you. Somebody else? Mr. Zaknowski.
So thanks for the presentation. When this call for land nominations goes out, to whom does it go and by what means?
It is open to the public year-round at this point. In the very beginning, we actually had a cycle that was open twice a year. So we would take an application during one cycle, and it was sorted the second cycle. We have since sped that process up to an open cycle year-round, so they can submit at any time when the application comes in.
Who's the they, though?
The landowners.
Okay, that's important, because nowhere does it say anywhere about the landowner having to make the application. I was going to nominate Mr. Clayton's land, but he may not want me to, and that's what I was curious about, whether so it has to originate from the owner of the land that's potentially going to be acquired.
Well, there is a path for nominations, but that still requires the landowner to be a willing seller. So we would, if their property is nominated, we reach out to that landowner to see if they have interest in the program.
Thank you.
All right, I had one more question. Anybody else? Okay. I'm looking this way, so. Yeah, I was just curious. I know that the program has been really successful with regard to partnering and bringing in additional dollars. What percentage of the closings that you have involve partner agencies, and any rough estimate on the amount of leverage we're able to accomplish with that?
Yeah, since the 2020 reauthorization, the new program has leveraged 4-to-1 for every dollar spent by Volusia Forever, $4 for partnerships.
Question. On your chart, if you go to on the right, what's the difference between the blue one? It says county staff presents application and eligibility evaluation to VFAC. Then you go over to, it says county staff presents property evaluation to VFAC. This seems duplicitous.
Well, the first evaluation is, does it meet the criteria of Volusia Forever? So is it eligible or not? That's the very first step. The second evaluation is a property report, and should it be sorted onto the A list or B list?
And where does all the money come from? If he nominates my property, I want to know how much I'm going to get paid.
The monies are based off state certified appraisals, and we get multiple appraisals and a review on each transaction.
Well, where do you get the money to buy my property?
The money comes from the Volusia Forever ad valorem tax.
Point
Is
of
there
order,
a-
Mr. Clayton, that's how much money does your wife get?
All of it.
Well,
Mr. Rectenwald.
and the partners too. I mean, like you said, a large portion. I was going to ask, so we are partners with many agencies. When we partner, what type of say do those partner agencies retain? Say you didn't, for whatever reason, although we would never have, if you wanted to sell that property, would they also have to agree to that?
Yes, if we have a partnership on a transaction, and there was a property brought forth to surplus, there is an entire surplus criteria for each agency that we partner with that it would have to go through as well.
Okay.
So basically, if we have partners in it, that's kind of a safety net about how it is sold.
Yes.
Correct.
Any further questions?
I just have a general question.
Sure.
Is Mr. Brown here tonight, Russ Brown? No?
Now, my understanding is he was unable to be here today.
Okay.
Anybody else?
But I have a great substitute. I have Gift Chumley here. Yeah, he's even better than Russ.
I'll be playing the part of Russ Brown this evening.
We'll ask Gift to tell his Coast Guard stories shortly. Any other questions? Mr. Dunham, thank you very much. I appreciate your time tonight. All right. Moving on to our item C in our general business. We're going to get into our reports and action items from each of our committees, but let me just start off by saying that I tried to attend as many of the subcommittee meetings as I was able to just to kind of watch the process, and I want to thank our two subcommittee chairs for doing just an outstanding job of kind of working through the questions that were presented to them and coming back to us in, I think, 2 short meetings each with recommendations that we'll be talking about this evening. So Pat and Ken, thank you very much. Appreciate your time and willingness to do that extra work. So I'm going to open up first and ask Pat Northey to report on the environmental committee chair, subcommittee meetings.
Thank you. Oh, I'm sorry. Is it on now? Okay. First thing that I think that we need to do is for the members of the committee, the subcommittee that were there when the last meeting was held, because we sine died that meeting, our minutes have to be approved. We're not meeting again, so we need to approve our meetings tonight. So if I could get a motion from committee members for the, Dwight, thank you. Is there a second? Thank you. All those, any changes or adjustments to the
Sorry, who
minutes?
was the second?
My name was misspelled.
Oh,
again.
was it?
Yes.
Sorry, I do
Okay.
apologize.
I believe it was those minutes. It was misspelled in a few different minutes, so.
Okay. Can we take care of getting Suzanne's last name spelled correctly? That will be the change. So all those in favor with that change, please signify by saying aye. Aye. Any opposed? Okay, that takes care of the minutes. Mr. Chairman, what would you like me to do next? There was, what we had was a ballot question with several opportunities to vote on different language that came before the subcommittee. We voted out, I think you have that in front of you, the ballot language that we voted out. But there has been some chatter since then, the public, and you heard some of it tonight, the difference of opinion about strengthening the ballot language that we originally said yes to. So I would like to ask you if you would like to explore that. And I have some comments down here that we could explore. There was also a sentence that was not voted through by the committee to forward about land needed for conservation.
So if it's good with you, I'd suggest we have legal present
I think that's fine.
what the proposed language is, and then we can talk about the
Yeah,
correspondence
yeah.
received and the
Thank
other
you.
suggestions that came in
Thank
from
you.
the public.
And Mike, could you speak to the Alachua, because that would be my preference, but I understand that that is not something that staff is recommending, legal is recommending.
So you have, there's 67 counties in Florida. 2 of them that we've been able to identify, Alachua and Orange County, have something in their charter involving basically the sale, disposition of conservation land, generally, I would say. You also have a state constitutional amendment. The state constitutional amendment was adopted in 1998. And the way we read it, it applies to entities of the state, and it governs basically the state, the way it's written. And property has to be designated by general law in order to be covered by it, and it requires a vote of 2/3 of the governing body of whatever state agency holds that property. About 10 years later, in 2008, Alachua County adopted an amendment to their charter, which we've kind of emulated some parts of Alachua and Orange in this proposal. It sets up a registry, as proposed here, of lands, and once the property is on that registry of conservation lands, it requires a majority plus 1 vote of the county commission to remove it. Orange County, and I'm sorry, I take it back. I'm sorry. See, I told you Giff was better than Russ. He's already corrected me. Alachua County required the referendum
Right.
to remove that land. Orange County was a bit different. They did not require a referendum, but they require the majority plus 1 vote of the county commission to sell that land. So what you have in front of you in your agenda packet would set up a registry of lands that are purchased by the county for conservation purposes. And once they're on that registry, it would take a majority plus 1 vote of the entire county council. So the entire, not, let's say 2 people are out on vacation, it's gotta be full vote, in order to sell it, divest it, or transfer it unless used for public purposes, or the land's taken by eminent domain. So let's say the state government came through and they wanted to put a bike trail through, they could exercise that eminent domain. So kind of the legal issues involved in this is, I think Orange got it right over Alachua in that by state law, counties, county commissions, in our case a council, have the authority to sell their assets, sell land specifically. So we don't think that the referendum requirement is lawful or enforceable. But I think the way Orange structured it is. And so this language would set up the registry, and it would take a majority plus 1 to sell it. So what's the rule now? Well, first of all, I'm not aware of the council selling forever lands. I'm not aware of any. Or it hasn't made a motion to do so. There's no transaction pending. But right now, it would be a majority vote if they did, like any other asset. This would increase the voting threshold required, like Orange County's proposal.
I've got a quick follow-up question, and then Mr. Johnson, I'll go to you. Mike, I know when we were talking about this, there was a basis for the determination on Alachua County, that model not being Can you, was it Sarasota County that had a similar?
Yeah, so,
Yeah, there's Sarasota County where there had been a charter amendment that had been passed that forbid the Sarasota County from selling any land. There are certain lands that were described in the amendment, and it was challenged. It went up to the district court there, and the judge wrote a very long opinion where it addressed it. And the judge wrote that because you have 125.35, which is the statute governing the county's sale of real property, which says that when it's determined in the best interest of the county, the board has the authority to sell it. They said that directly conflicted, that charter amendment, with the state statute and therefore could not survive. And they kicked that part of it out. The court also went on to address the referendum issue, noting that while there are several cities who have a referendum requirement when it comes to selling government property, cities are not constricted by 125.35. There's no analogous provision governing the sale of property by municipalities. And that's why those referendum requirements for those cities have been upheld by courts where they've been challenged.
Are you, just a quick follow-up, was there any challenge to Alachua's language?
I am not aware of any challenge. To this day, it just remains there. So, but my theory is that if it were tested under the reasoning of the Sarasota court, it would be found to be unconstitutional.
Okay. Mr. Johnson, I'll go to you, and then Ms. Northey, I think you had something.
I'm willing to make a motion at this time to accept the ballot language as proposed.
I have some questions that I'd like to ask.
We'll hold off on the motion for just a second. We'll finish discussion then.
Well,
How,
that is what I think that is the question, is that Alachua County has not been tested. Is that correct?
That is correct.
Okay, what
Not to
about?
my knowledge.
What about changing the ballot language to make it a unanimous vote of the county council?
I don't think there's a problem with changing the voting threshold as long as it's the county commission or in this case, the
So
county
that
council
is a
making the
difference for
decision.
the legal staff.
That is not addressed in the statute 125. The statute just says that when it's determined to be in the best interest of the county, and they would still be making that determination, it would just be a unanimous vote at that point.
Okay.
Ms. Schreiber.
the Sarasota case that you referred to, how long was that in effect for, the amendment itself?
It was challenged out of the gate, like once it passed.
Right, but this passed in 2008 on Alachua. How long was that?
It's,
No, I understand. So I'm saying the Alachua amendment was in effect since 2008. The one that was challenged and lost?
you're asking for the year that the case was decided. That was 2019.
Okay, and how long was it in effect before it was decided?
It was challenged once it was approved by the voters.
So it was approved and then it was challenged
Yeah,
automatically?
Sarasota County challenged it.
Orange County's charter amendment was adopted in 2024.
Okay.
And what is their threshold? Orange County, remind me.
I believe they have the same threshold we do. It's a majority vote plus one
Plus
of
one.
their county, of the entire commission. So you can't have like a
I
situation
think
where.
your commission is maybe 9. Is it 9? Yeah.
No, hold on, let me check.
Theirs was different because they did not have a registry of land. So
Yeah.
they defined it a different way. This is lands that are public parks and recreation areas that are owned, operated, and maintained by the county, and environmentally sensitive lands acquired by the county for environmental, ecological, or recreational purposes.
Okay.
There were notes in their approval minutes that talk about how they basically borrowed their definition from their own ordinances. So their charter amendment was sort of tailored to the structure that was already in place there.
Mr. Seknowski.
Just a couple of quick questions. The term conservation, is that defined anywhere in the charter?
I'm not aware of us having a definition.
So is the intent to interpret any, for example, land acquired through Volusia Forever as automatically I'm just very concerned about how we define conservation, because I might argue it's the swale in front of my house.
Yeah,
if
I
it-
mean, go ahead.
Well, the subcommittee, when they approved this, it's conservation lands, and we talked, I think there was a little bit of discussion about the problem with defining conservation lands, and that's why the registry is used here. And if it's placed on the registry, it's conservation lands. And also, the provision that came out of the subcommittee was that it has to be added by a majority plus one.
Okay.
As well as removed by a majority plus one. So the threshold is equivalent to get it on the registry as well as to get it off the registry.
Yeah, that was fascinating, I thought, too. Okay. Just to clarify, I think it includes the word transfer. Would that include swapping?
I mean, if we were to propose, I'll give you 5 acres, you give me another 5 acres, yes.
And because currently swaps between governmental entities in Florida don't
Yeah.
even require a public hearing. And that creates problems.
It would be I'm sorry. You know, I'm gonna step back because I think Giff, he sounds better than me.
And he hasn't had as much time to talk as you.
Yeah. That's all right.
I'm just going to note that anytime we're selling property, remember, there's also 125.35, which has a noticing provision in it. There is an element where you have to go through a public notice period under 125.35 to sell properties. So there would be a public hearing involved as well under that statute.
Except swapping isn't considered, and I'll give you a perfect example. Between the county of Broward and the school board of Broward, there were some swaps that didn't require, because it's between two governmental agencies, unless the laws changed recently.
There is also 125.38, which deals with when you are trading, or in that case, that would cover that. It is an exception to 125.35, and it is done to make it easy when you're doing things for a public purpose or things
And
of that nature.
that was my concern.
But
So-
transfer, in my opinion, as a lawyer, would mean that you are transferring the property out of your ownership to another ownership.
And that's
So
why I kind of thought it would be
cover
covered. I mean, I happen to agree with you, but I just want the public, everyone to know that swapping is a very interesting exception because the public doesn't get to weigh in on it, I promise you. Okay, the last question I had is, when it talks about the entire county council, we covered the absences, how about vacancies?
You basically would not be able to take that vote until that seat was filled.
Ms. Northey?
Okay. I have to ask a question about the unanimous then. Does that mean that it's tit for tat, that if came before them, the county council, would they have to unanimously accept it? Which I don't think, I'm trying to think back, I think every vote for Volusia Forever mostly has been unanimous. Before they, I mean,
You
if
mean
we
to
change
buy-
this to put
to buy the
unanimous in
land?
it. Yeah, to buy it.
Yeah. Well, you could write it differently. You could have a lower threshold to add the property registry and a higher threshold to
Okay.
sell it. It
You
just
could,
would
okay.
depend on
All
how
right.
you write it.
Yeah,
Would
this
that
is
have to
just
be in
for-
the, or is that by ordinance to buy it?
The way this is written now would be by charter. Council,
But buying it, they could buy it, we wouldn't have to put that into
no,
charter
I mean, if
amendment.
you could have a charter amendment that provides that higher voting threshold that applies only to the sale, transfer of the property, right, not the buying of it.
Okay.
Okay, Ms. Schreiber?
Is it appropriate for me to make a statement? Because I typed up something so that I would not forget my own words. So is that possible?
We can, sure, go ahead.
Okay. And then after I say this, I do have another question as
Okay.
well. So I will not be voting for the Volusia Forever Charter Amendment that we're presented with today. While I did vote for the amendment in the subcommittee meeting, it was because it felt as though there were only two options: to allow the county to sell the land or to vote for this amendment. No one said this, so this is not an accusatory statement, and I appreciate Mr. Russ Brown's patience and position. It felt that way in the moment, and I'm on record stating that I resent being put in this position. So from the minutes following the vote, I asked whether the approved ballot language represented the only legal permissible method for protecting conservation lands or whether alternative approaches could have been pursued. And I noted that the subcommittee members are not attorneys, and I sought clarification on whether other viable options existed. I'm not going to read all the minutes, but Mr. Brown responded to me in those minutes. So in the meeting, by Robert's rules, I didn't feel that I could rescind my vote because I asked the question after I voted. If that's not true, then I would like for legal to weigh in on that. But the amendment is not what the voters voted for. And I believe that as charter commissioners, we should do our best to protect what the voters already voted for at 75.6%. The letter from the Trust for Public Land states that Alachua's action of creating a registry and allowing the disposition of public land only by a vote of the people is what this commission to pursue for protecting our Volusia Forever conservation lands. This is what I personally prefer. I understand what they're saying. If it's been in effect since 2008 and not challenged, I would say that's quite a while. We are partners with the Trust for Public Lands, and we need to be listening to them as Clay Henderson, who has always supported their stance, and the county's partnership with that organization. The public did not vote on open public purpose in the sense of what these lands could be used for now. And I would just like to see us support what the public voted for. Thank you.
Thank you very much. All right, so let's bring this back. We've had good discussion, good questions, I think. Let's bring it back to, I think, what the options are. We've got a recommendation that came out of the committee with the language that you have before you this evening. We have heard, I think you've seen the correspondence that was also received both from the Trust for Public Land outlining the Alachua option. You've heard our legal counsel opine with regard to that. We've also got a letter from Melissa Lammers that proposed that we add findings that are consistent with, I think it's section 18, I can't remember what article it is, out of the Florida Constitution with regard to findings relating to the land not being needed for conservation purposes any further. So at this point, I'd be open to a motion for one of the options that are outlined there.
Mr.
I'm
Chairman.
going to make a motion that we accept the ballot language as proposed by the committee at this time.
I've got a motion. Is there a second?
Second.
Second from Mr. Lewis. Is there discussion on the motion?
Yes.
Ms. Northey?
I happen to agree with Ms. Schreiber, although I understand the concerns of our council, and that is why I was wondering if we could change that to a unanimous vote of the county council. I think that's a much higher standard. Also, there was language, Ms. Lammers had talked about land no longer being needed for conservation. I'd addressed that and offered that as a statement when we were in subcommittee. It was not adopted, but I would like to just read it. Upon council determination that the land is no longer needed for conservation. I know from talking to Mr. Brown that there was that was language he did not support it or not support it. He just said that he didn't think that it was necessary, and I would be interested in hearing what council could say about that language, because I think that speaks directly to our concern that we have to say something about the land not being needed.
Well, in a typical scenario under 12535, it's if the council determines it's in the best interest of the county. That's a bit broader than making a finding that it's no longer needed for conservation purposes. Obviously, if you have a conservation land registry and you're putting property on it and you're taking property off, when you put it on there, I think it's implicit, and you probably would find those findings in any resolution that was drafted to put it on there, that it is needed for conservation land purposes, and that's why it's going on the resolution. And if you voted to take it, if you had a resolution voting to take it off, then it would be implicit that it was no longer. If you're looking for an express statement, I could just tell you from drafting resolutions, you'll usually see statements to that effect in the whereas clauses on the resolutions, supporting the resolution or the reasoning behind it. So I believe the reason Mr. Brown said he did not think it was necessary is just the very virtue that you're putting it on the conservation land registry or you're taking it off speaks to what the council is determining from a legislative standpoint. If an extra statement if it were so the committee's desire to have that extra statement added to the charter amendment, I don't think there's a problem with it. But, again, that is up to the committee.
Okay, let's go back to we've got a motion and a second on the floor. Any further discussion on the motion, understanding that,
Well, that changed it, yeah.
Well,
I won't be voting.
Did
for
you
the
make
motion.
are you proposing an amendment to the motion?
I was interested in, yes, I'm proposing an amendment to the motion that would add language upon council determination that the land is no longer needed for conservation, and also that we make this a unanimous vote.
And that's okay, so the no longer being necessary for conservation is to replace public purpose then?
No, that would be, it would read, shall the Volusia County Charter be amended to establish a conservation land registry allowing the county council to add or remove land by a majority plus one vote of the entire council? I would change that to unanimous. And then add, upon council determination that the land is no longer needed for conservation, and land land on the registry will not be subject to sale, divestiture, or transfer by the county unless for public purpose or the land is taken by eminent domain.
Okay, don't worry about the language on the top, that's just an explanation of it. The language that matters is the underlined. So you're really saying that you only really want to add the unanimous thing to remove it, not to add it.
let's go back.
She's trying to make a amendment motion. I'm trying to understand because the motion's on the table. We're talking about an amendment right now.
Correct.
So are you saying just to amend it to remove it from the registry?
No, I don't want to remove it from the registry.
No. So the unanimous part, because the way you just said it to us was it would be to replace it on both sides, and I don't think your intent was to make it unanimous to add the thing.
To clarify, I think what you're saying is keep the lower threshold on adding it to the registry,
think
make
that
it
was the
unanimous to
intent.
remove it from the
Right.
registry, and then have the conservation purpose finding included as well.
Is that what your
No.
intent was?
No. My intent was to change make an amendment where it says majority plus one vote to a unanimous from the council
To remove.
to remove.
I think the question Mr. Seknowski is asking is, do you need the same unanimous vote to put it on the registry?
Oh, no, that's why I
That's
said
what I thought.
conversation,
Okay, I'm
and the
just
staff said
clarifying that
no.
because the way you said it, it would be. And that's what I'm
I
saying. Your
don't-
intent is to say added to by a majority plus one and removed by a unanimous vote. That's your intent.
Okay, I understand what you're saying.
Okay.
Yeah.
So
And then in addition to that was to add that there be a declaration by the council that
That
it
it
be
was
no
for
longer needed for.
conservation, yeah.
I'll second that amendment for the purposes of the discussion.
Was that that was a
Yes,
motion?
it was a motion.
That's a second. All right. So discussion on the proposed amendment to the motion. Mr. Johnson?
I've been on the council, I've watched council since I was a kid, and you can't get a unanimous decision on what time to have a free lunch. There's safeguards in this already, and the fact of the majority of these properties are bought with other people involved, that they have to approve of it before you can get rid of it anyway. So there's more safeguards in there than we're really thinking about looking at right now. Now, I'm not for selling the properties, don't get me wrong. I voted for this proposal when it came through both times to buy these lands. But I think you need to leave some stuff in the hands of the county council because we don't know what's going, what may come up. They may have something very advantageous that if they do, they can make up somewhere else better. It may have come up to where the county manager has to have something and they need it that will save the county money or be advantageous. We don't know what the government's going to do in the future, and you don't want to take and totally handcuff your people so government cannot function 20, 30, or 40 years down the road. That's a very dangerous situation. I don't want to see the property sold. I think it's up to the citizens when something comes up to lobby their county council. Yes, you have county councils that come and go, and some of these things could cost the county council their positions. So I think we need to take and not overreact. I'm going to stick on what my motion is.
Okay. Any further discussion on the proposed amendment to the motion to?
In the committee that that came up with this proposal, was this discussed a lot at the committee level, unanimous versus majority plus one? And so y'all had an opportunity to consider that as a committee, a lot more than we're hearing it today, right? And y'all came up with a majority plus one, as opposed to unanimous.
That was.
Correct?
That was the way it was originally presented, but that is a subcommittee, not the
No, I got
committee
it.
of the
I'm just
full.
trying to figure out, the subcommittee presented this to us, and I give great deference to our subcommittee.
So there were,
Wait, I'm not done. And so it would require, as I understand it, they all have to be there. It'd be 5 votes, which is a supermajority, a majority plus 1. So if I defer to the committee, the subcommittee, and I agree with Ben. I think if unanimous is, especially if to get on the list requires a majority plus 1, why would you not have the exact same vote to get off the list? And I think you're adding another hurdle, if you will. Some judge in the future is going to say, why did y'all do that? It should be consistent for getting on and getting off. You can't have it both ways, in my opinion. So while I certainly agree, I don't want any land sold. But I think if you make it unanimous to get off, somebody's going to say that's a barrier that's too high of a barrier, and I can see some District Court of Appeal reversing it. So I'd stick with the language as it is, and I think, I don't disagree with the language in the letter is no longer needed for conservation purposes. If it's, how do you define that even? I think Mr. Sandusky said, what does that mean? I guess if you're on the registry, it's conservation, but conservation is not even defined. So that's causing another issue that's going to pop up. You're clouding the issue.
Okay. Any further discussion on the amendment to the motion?
I was
Madam-
just going to say
Ms.
that
Schreiber.
it's only been 5 years since the public voted. It's not like it's been, a really long time. And as far as the subcommittee itself, I'm not even sure how many members were supposed to be on it. 4 members showed up to our first meeting, 4, and 5 members showed up to our second meeting, and there was someone that was supposed to be there that didn't attend for whatever reason. And as far as how long we discussed it, I believe our first meeting was around 48 minutes. Our second meeting was probably close to the same amount of time. I'm just answering your questions.
Okay. Mr. Johnson?
The chair put a committee together. The committee brought us back something, so I think it's a little bit late to challenge why and what happened at that committee.
All right. So we've got a motion on the floor to amend Mr. Johnson's motion. Madam Secretary, and just to make sure that everybody's clear on what we're voting on, this would be the vote on the amendment to add a unanimous requirement for the disposition, the sale, or transfer of any property that is on the registry, and to add the finding that it is no longer needed for conservation purposes. Is that properly stated?
And that to put it on there is a majority plus 1, is that what we're sticking with?
Remained unchanged.
I just want to make sure I understand.
So that is the motion you're voting on now before we get back to the main motion. This is on the amendment, the proposed amendment. Madam Secretary, can I get you to call the roll?
Ms. Bright? No. Mr. Clayton?
No.
Oh, he's not here. Mr. Johnson? No. Ms. Quietek?
No.
Mr. Lewis?
No.
Ms. Menizzi?
No.
Ms. Northey?
Yes.
Mr. Parker?
No.
Mr. Sakonovsky?
No.
Ms. Schreiber?
No.
Mr. Tolland?
No.
Mr. Watts?
I'm also going to vote no.
Ms. Wheeler? No. Ms. Walford?
No.
Okay, so it brings us back to the main motion to proceed forward with a recommendation of the committee's recommended language as presented. Is there any further discussion on that? If not, Madam Secretary, if you'll call the roll on that.
Ms. Bright? No. Mr. Clayton?
Aye.
Mr. Johnson? Yes. Ms. Quietek?
Yes.
Mr. Lewis?
Yes.
Ms. Menizzi?
Yes.
Ms. Northey?
Yes.
Mr. Parker? Yes. Mr. Sakonovsky?
Yes.
Ms. Schreiber?
No.
Mr. Tolland?
Yes.
Mr. Watts?
Yes,
Ms. Wheeler?
Yes.
Ms. Walford?
Yes.
okay. Well, again, thank you for all the discussion and that, and time you spent talking about that. I think certainly an important issue. And I think we are adding to the protections with what's being suggested, should the voters choose to adopt it. With that, I'm going to move to our next item on the agenda, which is Mr. Parker's subcommittee and his report. I'm sure this is going to be the long one, right, Mr. Parker?
I believe in short meetings. Our subcommittee has met 3 times, and I really appreciate the input from each of our committee members. It was a very good discussion, and we reviewed a number of the items. And I've told the committee I would report that we had a very good discussion on how many members should be on the county council because of our growth in population and things like that. So I'd like to report to the committee that we actually had that discussion, and the majority of our committee is recommending that we maintain that number at 7 at this point. And so that was part of I told the committee I would report that to the full commission so that you were aware of it. That we looked at the whole charter, and as related to each of the issues that were brought up in the group, and the recommendations that we are bringing forward are those that we believe are charter provisions, and some of the others that were in our listing could be handled through other mechanisms available through the county. And so there is a clarification of language in Amendment 10. And so Amendment 10 made some changes as related to the constitutional officers versus elected department heads. Plus, it added the tax collector to that particular item. We also had a discussion of some of the other provisions, and you've seen the ballot language there. For the complete commission, I will disclose, I had a discussion with the tax collector on Friday, and again, I got a text message back from him today. And his question related to budget, as I recall, and as I conveyed to him, there's a constitution provision and plus statutory. And from the committee's provision, we thought that if it was covered by either the Constitution or statute, why clutter the charter with those types of items? So if you begin to look at our charter language as it related to cleanup language, I think that is pretty clear. I think the county attorneys have done a good job of trying to clarify that particular area. So you want to take each of these by themselves, Mr. Chair?
Yes, I think that's best. So that's I think, report on the Amendment 10 ballot language. Are there any questions on that ballot language? If not, is there a motion on that ballot language?
I move that we approve the ballot language.
Second.
Second.
And multiple seconds. Mr. Johnson was the first one I heard. All right, we've got a motion and a second. Any further discussion? All in favor signify by saying aye.
Aye.
Any opposed? Okay, Mr. Parker, number 2.
Okay,
B.
we had some discussion concerning actually some of the structure of the council, and it related basically to the chair itself. So the ballot language that is being proposed would take the chair back to an appointed, actually elected from within the body, which was what it was for many, many years as it related to that particular item. And there were some other changes as it related to a clarification, as it related to the number of years that a council member could serve and all of that. And at our meeting just prior to this, we had some amendment language, and that has been handed out and provided to you. And based upon that, I'd like to make a recommendation and a motion that we approve the ballot language.
Is there a second?
Second.
I think I got Ms. Munizzi on that one. All right.
Tie goes to the
Any
winner.
further discussion on that?
I have a question.
Ms. Schreiber,
How long have we currently been,
with the current chair structure? Bruno, Davis,
Since-
Kelly,
2002, that's when the amendment was
2002.
passed, yeah.
Been 20 years.
yeah, about 20 years.
okay.
Any further discussion? All right. All in favor signify by saying aye. Aye. Any opposed?
No.
It's 2 opposed. Okay, Mr. Parker, number 3.
There were a number of provisions in the charter as it related to personnel and personnel administration. And in the discussion in the committee is that many of those provisions should be left to the county council, should not be in the charter. Sometimes they're sort of hamstrung, and we went through a fairly detailed discussion about some of the items and the pros and cons. And so we're recommending that language from the charter be removed, that some of the personnel items that were included in the charter be removed, and those be referred back to be adopted by ordinance by the county council. Okay, based upon our recommendation, I would move the adoption of the ballot language.
Is there a second?
Second.
Ms. Wheeler got that one. She's been waiting. She's been waiting. All right. Any discussion on the motion? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. All right, Mr. Parker, your last one.
Okay, our final related is related to the compensation, and we had a lot of discussion about this particular provision. And, okay, and we have proposed to take out the provision related to that it's the total compensation and that council members is not currently eligible for reimbursement of certain expenses within the county. And so that's our recommendation to the full commission, and based upon that, I'll make a motion, the adopting of that particular provisions.
Got a motion and a second discussion.
Just clarification on what you just said, the miscellaneous expenses will now be reimbursed?
Okay. No, I didn't say that. We're removing that provision as it related to that it's your total compensation. So you're not eligible for, county council members are not eligible for reimbursement of business-related expenses currently.
Currently, right.
Yeah, this would remove that and place it into where it could be adopted by ordinance.
Okay, that's, okay.
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 Any further discussion or questions? All right, we've got a motion. Who had the second on that? Ms. Wheeler again, she's on a streak. Got a motion and a second, no further discussion. All in favor signify by saying aye.
Aye.
Any opposed?
No.
Got 2 opposed. All right.
Can I just have
Motion
clarification of
passes.
who was opposed, please?
Ms. Bright and Ms. Schreiber.
And can I have the same clarification for the last one, that where there was opposite?
Ms.
same-
Bright and Ms. Schreiber, I believe, on the prior one that had 2 negative votes.
Mr. Chair, that completes the report from our subcommittee. Thank you for allowing us to conduct the meetings and then provide this report to the full body.
I thank you for your work. Ms. Northey, I thank you for the work that you did on your committee as well. We'll move on in the agenda. At the last meeting, we had a presentation from the Volusia Growth Management Commission on who they are and what they do and how they presently operate. And wanted to bring this back up just to see if there was any further thoughts from the commission on whether we wanted to do anything with regard to the language in the charter currently about the VGMC. Seeing none, we'll move on to the next item. So from an organizational standpoint, I believe we've now adopted 5 proposed charter amendments that will be moving forward to our report to the council and then ultimately to the ballot. We are now at the point, I believe, where we need to start looking at the messages that we want to send along with those ballot questions. We've had a lot of discussion that's taken place here over the meetings over the past several months. A lot of input from the public, and a lot of things that we heard the same response on is you're preempted from that. But we did talk a lot about including those messages along with the report and the ballot language to the council. So We have mentioned now that we've got two committees that have disbanded, I think we need to put together a committee that will work on the drafting of that report and recommendation letter. I wanted to start out with, I guess, getting a show of hands on folks that would be interested in being involved in that committee. Mr. Seknowski?
Will you raise your hand?
Yes, I'll do.
Mr. Parker?
No, the
Ms.
rest is on my
Munizzi? Ms.
chin.
Northey? And I'd actually like to participate on that one as well.
I have a question before
Yes, ma'am.
I would decide that.
Yes.
Senate Bill 180, is that, my understanding is from, it's going through committee right now, that would, instead of being effective next year, that would end, what, July 1st or sometime in?
It's just summer. Yeah. Would shorten that deadline that I believe is effect until 2027.
So some of the things that we were not allowed to discuss before, we
Or
could,
propose, yeah. Unfortunately, I hope the amendment to the Senate Bill 180 passes. Unfortunately, it kind of puts the Charter Review Commission in a position of it's late. You know, if that bill were to pass, and you could propose those things over the summer.
And my-
You got real soft at the end.
I said, I hope the amendment to Senate Bill 180 passes, but the phase out under that one amendment is almost too late to be of any help to the Charter Review Commission. It can help local governments, but for you to be able to propose something.
Well, I don't think that's necessarily the case, because if it were to go, I personally just don't think it's going to pass. That's what I think the problem is. But if it were, and it were to go into effect July 1st, this commission would still have some time, because we know if the law were passed well before July 1st, the legislature won't make it retroactive, obviously. So I just think we have to wait and see is where I would look at it that way.
Well, and I think that's a good approach. My understanding is the Senate bill is proceeding through committees. The House bill has not really proceeded through committees and isn't really getting any attention. So the question will be if it comes through both. So I do think, Mr. Seknowski, you're right. We will have some time while we're still organized to be able to deal with that if it comes up, and if we have time before the end of our term.
Mark,
So I've got 5 people for a committee.
I just want to make a comment.
Yes, sir.
The county council has the authority to put amendments on themselves.
That's correct.
So if there's some things that come up, they can put them on there.
And so I think that's where the recommendations that we're talking about, including in the transmittal letter, are important. Mr. Johnson?
Mr. Chair, I'm not on that committee, but I would recommend that the possibility the committee consider the fact of electric cars in reference to a tax. They give that to the county council as a recommendation to look at.
Because of their
Electric cars do
exemption
not
from the
pay the
gas
gas tax,
Right.
but they take as much toll on our roadways as any other. I don't think it does not belong in charter, but I think it's up to them that we send to them for them to possibly look at it and take some kind of action, either themselves or to recommendation to Tallahassee.
And I think the recommendation to your point, Mr. Johnson, we will, I think the committee that we're forming now will draft that report to come back to this body to review and approve. So you'll have an
And-
opportunity to make sure we're including that.
And we can see how it goes, but just be mindful under the charter, once you give your report to the council, they got to conduct 3 public hearings
Correct.
on your proposed changes. And you got to get the ballot language to Lisa by early August.
Right.
For her to make the general election.
Yeah.
That's just something to be cognizant of.
So we're only ahead of the game at the moment. Ms. Northey?
I just want to confirm, Mike, that they don't make changes to our questions. They don't have that authority, correct?
Right.
Okay.
Correct. Okay, so we've got the drafting subcommittee. Madam Secretary, did you get all those names?
No, I've got Mr. Seknowski, Mr. Parker, Miss Northey,
Ms. Munizzi
Miss Munizzi.
and myself.
Okay, thank you.
Anybody else that, Ms. Schreiber?
I will, and also, I'll wait a minute.
Okay. Ms. Schreiber will be on that as well.
So is that 6?
Yeah.
It is 6.
Okay. And so what this committee has done, what you have produced in the past is there's a set of bios for each of you. There's a summary of what you're proposing, and then the actual language like you just adopted tonight are attached as a report to the council.
Mr. Seknowski?
That's fine for the past, but as we've established at numerous meetings, there's going to be an additional responsibility of this subcommittee, which I know Mark's going to say something.
Correct. Okay.
So I will, so I'm going to go ahead and ask this question. She asked, Ms. Northey asked if the council could change our amendments? Is that what you were asking?
Change or whether they could deny putting on the ballot. My understanding is no. They have,
Correct.
all they do is conduct a public hearing.
Unless it's a land use
Unless
amendment,
it's outside of our purview.
which
Referring-
you don't have those currently.
They were
So-
referring to the ones we've already passed. They were not making any opinion as to what we may try to pass. And he's absolutely right. State law has created an additional hurdle, if you will, that if this body were to do something that was interpreted as being land use related, then the commission would have a separate vote on having it and would have to pass that vote. And in addition, it would have to be a more than a simple majority because of the way the charter is currently written. We talked about this somewhat in our subcommittee, but that is the clarification. None of the things we did tonight are going to be anything but rubber stamped. But if in the future, between now and the end, when we disband, if there was somehow a passing of a land use related, specifically land use related amendment, then it would have, assuming it was legal, would still have to be additionally voted on.
Well, how would Volusia Forever not be a land use amendment?
It's, Mr. Dyer, you want to respond to that? How is Volusia Forever not a land use amendment that's preempted to the council?
Involving purchase of property rather than regulating that property.
Proprietary versus regulatory?
It's not the use of the property.
Well,
Right.
that then raises a question. When I was on council, we always changed them to conservation land by zoning.
Right.
Does that,
That's a separate.
okay.
That's a programmatic thing within the Volusia Forever program. Okay, so we've got a committee formed for the drafting of the subcommittee, or for the drafting of the report and recommendations. My suggestion would be for us to go ahead and have that committee meet between now and the next scheduled meeting. Go ahead and keep our next scheduled meeting so that we can come back as a committee and give a report on what the outline of the topics that will be included in that report will be, to make sure we're not missing something that somebody wants to make sure is included before we do a final
And
draft.
my only suggestion, I'm looking at you, Ben, because you look bored. It could be anybody, but I would recommend you have an odd number in case you have a tie vote.
That is a fair point.
So
I was going to ask earlier, we had 4 people, so we didn't vote at that meeting, not on a final amendment, but what would have happened had we voted with the 4 on the subcommittee?
I'm sorry, can you say it again?
We,
If there's a tie, it fails.
The
fails.
motion doesn't pass.
Yeah. Is there one other person who'd be willing to serve on the committee so we can have an odd number? Ms. Bright?
And just keep
Okay.
in mind that doesn't mean they're going to be there. So that's why it can happen. It doesn't really matter how many you set up. It matters who's actually showing up.
Correct. Okay, so we've got Ms. Bright added to the committee, so we have 7. We will work with the Madam Secretary to get that scheduled and have that outline prepared for the next meeting. If everybody agrees, that will be our agenda at the next meeting, to go through that report.
Yeah, Mr. Chair, just a clarification. Also, this committee also has the ability to make management recommendations.
Correct.
Is that part of the committee's work in the drafting?
Yes, sir.
Okay, I just wanted to get that clarification.
Yeah. Okay. Mr. Seknowski?
It's up to you, of course, but in the past, you appointed the chair, and you have to go to public anyway, but you appointed the chair, and you continue to do that, you want the committee to determine its own chair.
What's that? Yeah,
He's
Mr.
gonna vote for
Seknowski,
this
would you like to chair that committee, Mr. Seknowski?
I can add it to my plate, but yeah, I'd be happy to. I think
Okay.
think people would be happy.
All right, then we'll go
Yeah,
ahead and have
and-
Mr. Seknowski serve as chair of that committee.
And just to be clear, and I know you've discussed this as a commission, you have charter amendments, which is you spent the lion's share of your time, but you can also make recommendations of ordinances. So when I heard operationals, it's ordinances.
And,
you know,
and we
recommend-
have a number of those from our original lists that we talked through that
Yep.
we kind of put a pin in to bring back for this purpose. So, okay. Well, I think that concludes our business this evening. Anybody else have any other business we need to talk about? All right, if not, then we are adjourned.
Thank you.